Please court. Counsel, apologize in advance. I'm a little under the weather. Apparently, colds are no longer social distancing as well. So I'm sorry if I have a little coughing fit. But the issue before you, the question before you today is whether an attorney can be sanctioned after complying with the rules of civil procedure to the letter and in good faith.
Can you state your name for the record?
I'm sorry, Your Honor. Carl Mitchell on behalf of J. Carlton Mitchell Esquire. I may reserve 5 minutes for the rebuttal.
Yes.
Now, in order to answer that question, we need to look at the events leading to the sanctions in the breach of oral contract act. In that case, on October the 26th of 2020, 8 days before my client's deposition, I received interrogatory answers sworn to under oath as interrogatory answers are, indicating that Mr. Carey, counsel for the opposing party, was present at the formation of the oral contract. Fearing that he may be a material witness.
So wait, your client, she was present for the formation of the oral contract, right?
Correct.
So she's known from day one. She didn't need Mr. Carey's responses to interrogatories to figure that out, did she?
Well, it wasn't Mr. Carey's responses.
Well,
it was the
excuse
party.
me, the responses to the interrogatories.
No, but it's important though, because I questioned Mr. Carey about that earlier in the case, and he assured me that wasn't really the case. He was there at the mediation, but he hadn't been there at the consummation of the agreement. Okay, I took him at his word. The interrogatory was specific though. It said at the time of the oral contract, and it was a very standard interrogatory. Tell me about the details of the oral contract. Tell me about the terms. Tell me where it took place. Tell me who was there. And the answer was myself, my ex-wife's attorney, and Mr. Carey. Now, again, that's under oath. So based upon that, I had this fear, I think it was at least founded, that Mr. Carey may be a material witness. So I filed a motion to disqualify. And on the same day, I filed a motion for protective order. And that was 2 business days after I received the interrogatory. On that same day, I advised Mr. Carey that we would do our best to set that motion for protective order and motion to disqualify for hearing. But if we were unable to do so before the deposition, then neither myself nor my client would hear. And again, I hope that the court understands why. Because ultimately, Mr. Carey is a material witness and he is going to be disqualified. It would be improper for him to take the deposition. The filing of the motion for protective order is really the most important. And it's the most important part because there is a provision in the rule under which I was sanctioned that specifically addresses what happens when you file a motion for protective order. And that portion of the rule is 1.380D. The title of that section is failure of a party to attend own deposition or serve answers to interrogatories or respond to a request for inspection. The last sentence says, the failure to act described in the subdivision may not be excused on the ground that the discovery sought is objectionable unless the party failing to act has applied for a protective order as provided by Rule 1.280C. Now, that's exactly what happened in this case. And then, frankly, from my 20 years of practice, that's always been my understanding, that if you bring a motion for protective order in good faith prior to a deposition, and you cannot get a hearing despite a good faith effort to set that hearing before the deposition, it's okay not to appear pending the court's rules. Now, keep in mind also in this case that the earliest hearing date we could get, we tried in good faith, was November the 12th, which was about 2 weeks after the scheduled deposition. My client did voluntarily appear after the lower court denied the motion for disqualification, denied the motion for protective order, which obviously the disqualification was not going to happen. That was part and parcel.
You would agree that the determination of entitlement to a fee award as a sanction under 380 is discretionary, wouldn't you?
I would.
Okay.
I would.
Let's talk about whether and the situation with regard to the expert supporting the amount of the fee award.
Yes, Your Honor. So switching to the reasonableness of the award, we, as attorneys and judges, we use the phrase, it is well settled in Florida law quite a bit. I've read it, I've said it several times, perhaps the panel has as well. Maybe it's a bit overused, but the proposition that you must have an expert witness testify to the reasonableness of your fees is truly well settled. I believe I cited a case out of every district, certainly multiple cases from the 2nd district, and certainly multiple cases from the Supreme Court in my brief that stand for that proposition.
And the cases that you relied on out of the 4th DCA distinguish a case from this court that Judge Altenburn wrote the opinion in called Eve's Garden. And in that case, Judge Altenburn suggested that to the extent a sanction is to some extent a form of restitution, a trial judge has the discretion to impose a fee award based upon a calculation of the actual rates charged, so long as those rates are reasonable in light of all the circumstances. Could it be said that that's what Judge Baggy Hernandez did here?
I'm afraid not. Again, the key word there is reason. And again, you have to have an expert testify to the reasonableness of the fee. I believe, a few years back, and I don't know if this law is still in place, when the mortgage foreclosure crisis was happening, there was a carve-out statute that was enacted, maybe the court recalls this, that allowed you to, I think it was for $2,500 or less, it was a relatively nominal amount, to be able to get attorney's fees without an expert. That is the only law I am aware of that allows you to.
So if you've asked in your brief, and if we were to agree with you, your request on the entitlement and the propriety, or well, if at least we were to agree with you that the determination of reasonableness was improper owing to the lack of the expert, you're asking under the authority of the Tracy Wells Fargo case that we should straight up reverse and that your opponent isn't entitled to a remand for an evidentiary hearing. Explain why.
Well, first of all, because this court has previously said that's what needs to happen.
Well, that's one read of Tracy, but there's a whole line of attorney's fee cases that are specific to this situation that say if the party seeking the fees has established something, not a complete failure of proof. And Wagner is one of those cases, if I'm not mistaken, that the proper disposition is to remand. And I think we have the most recent pronouncement was this year in Soto versus Carolwood. And here it would seem that your opponent put in evidence as to the lodestar requirements and offered Mr. Scarrett's affidavit, which was excluded, and requested a continuance if the judge wanted to conduct an evidentiary hearing with regard to reasonableness. So why doesn't that put us into the territory of there's sufficient evidence to warrant a remand?
Well, first and foremost, I do plan on circling back despite your question earlier to the entitlement issue, because I don't think it's entitled to it. But be that as it may, let's assume for a moment that the entitlement issue is not being put forward. There are a couple of things. First and foremost, it's not like this was a surprise issue. I raised this issue at the hearing.
Was the hearing set as an evidentiary hearing?
Yes, it was.
So the notice of hearing, in the record, if I look at the notice of hearing, it's going to say that it was set as an evidentiary hearing.
Yes. So it was set as an evidentiary hearing, and I believe that the intention all along was to bring the expert, but I don't recall the reason. There was a reason why the expert wasn't present. The affidavit was submitted and properly excluded by Judge Baggy Hernandez as being hearsay. At that point in time, you know, again, I think we're talking, I've heard you question some other attorneys, and I think you focus a lot on pragmatism and practicalities, and I think we're talking about pragmatism and practicality. At that point in time, if your expert can't show up, where does that burden rest? What needs to happen to that?
Well, under your opponent's view of the facts, he suggested a continuance.
I don't recall him doing that. Maybe I'm misremembering the record, and I'll rely on the transcript itself, but I recall him going full bore and saying, no, you don't need that. You don't need the expert.
Well, two things can be, both of those things could be true. He said you don't need it. And he also said, if we're going to have an evidentiary hearing on reasonableness, I would like a continuance so that I can bring Scarrett live.
Yeah, and I don't recall that, but again, I'll rely on the transcript itself. What I do recall, though, is that I raised the issue that Mr. Scarrett wasn't there to testify live, and by the way, was over the phone during COVID, so it's certainly live is a different thing. And that I raised the issue and said, no expert, no fees. He's entitled. I think I literally said he's entitled to zero because he did not bring an expert. At that point in time, Judge Baggy Hernandez took a recess and researched the issue and came up with the two cases he came up with, which I respectfully point out really aren't at all on point or
I don't disagree with you that those cases are not the best cases for the proposition that he cites for, but you would agree with me that we are bound to affirm Judge Baggy Hernandez if there's any reason to do so that's apparent in the record, even if his cases are not straight on point.
Well, sure. Everybody understands that if you get to the right result.
I looked at his cases in the order, and one of them was mine, and I have yet to see a case cited in this case and to indicate that you don't need the expert present. As far as I know, you do.
That's the point, Your Honor. And again, without an expert present, it just seems well settled in Florida law that you can't get the fees. Now, going back to your question, why can't he get a second bite at the apple? Again, respectfully, I understand the fourth DCA may have questioned this court, but this court's been clear, and it needs to be consistent, that where you have an evidentiary hearing set on attorneys and you fail to prove your case, you don't get a second bite at the apple. I think there's a policy reason behind it. And I think it's well settled. And if I might, Judge LeBrit, unless you have any further questions on that issue, may I go back to my entitlement? Yeah. So the entitlement argument, I agree, it's discretion. But again, we have to look and see whether the discretion was abused. And if there is no basis in law, and if there's no bad faith found, then I would respectfully argue that it wasn't abused in this case. Again, just talking.
And how can you say that any reasonable trial judge would not have sanctioned based upon what happened here?
Again, because the rule itself, there are two things in play.
But the failure to appear is in D, if that stands alone for a party's failure to appear at the deposition.
Correct. And that's what happened. And indeed, there's that safe harbor provision that I mentioned before. A motion for protective order was filed. Now, listen, I'm not suggesting that if you file a motion for protective order, that's ridiculous. My client's not going to show up for deposition because it's random, right? Or that there's some totally bad faith reason. That's what Moakley v. Smallwood is for. Okay, it's the backstop to show that the bad
But
faith.
your client could have shown up easily at the deposition and you raised the objection that you weren't able to get before the court.
So I don't know, I have her show up, I go through the process of wasting Mr. Carey's time, go through the process of having her show up at the deposition, okay, saying, I'm sorry, she's not gonna testify because I think you need to be disqualified. I think I did the right thing by telling him at the time I filed the motion and said, listen, we're gonna try real hard to get it set, but if we can't, we're not gonna be there. Let's let the judge decide. And again, to be clear, that motion for sanctions was just that. It wasn't a motion to compel. It wasn't a motion to force her to come to a deposition. And we've got to look at two different things here.
But the rule that they're proceeding under doesn't require a motion to compel.
Right.
It's the simple fit, and if you look at some of the cases, some of them completely dismiss the cases. I mean, this was on the lesser, just sanctioning fees.
I would respectfully suggest in those cases an order was violated. And that was the point that I was going to make is that when you are.
But you don't need to proceed under D to get a violation of an order. You simply just, as a party to an action, just fail to appear.
But again, it's kind of a pick your poison sort of situation. That's why I inquired, was there bad faith, Robert? No, there wasn't bad faith.
And you don't need bad faith. You need a willful action. Which
Correct.
you found.
Correct, but it's a two-step analysis. So under D, the fees are related to the party's failure to show up. As I pointed out.
Which is your reasonableness argument that they exceed reasonableness.
Well, it's kind of I hate to say this, but it straddles both, right? Because at the end of the day, if D specifically says the fees are related to the party's failure to show up, and the motion for sanctions doesn't ask for the party to show up. Again, keep in mind, the motion for sanctions didn't say compel anything, make her come.
And it's a sanction for failure to show up. It didn't attach the certificate of non-appearance.
Certainly, and as I told Judge Baggy Hernandez, to the extent that he wasted a half an hour waiting for my client, which I don't think he did, to the extent that he burned $75 reporter appearance fees, yeah, the D absolutely covers.
Well, what about the part where he, until the day you file your motion to disqualify him for protective order, is proceeding with the idea that he's going to take this deposition and incurs time to prepare, which that time gets lost, and then has to deal with the fire drill associated with your what might be fairly characterized as an 11th hour protective order.
Well, with respect, 6 days before deposition, I don't think there's a fire drill or an 11th hour. And again, to be clear, 2 business days after I received information under oath that he may be a material witness is the best I could do in that situation. I think it's reasonable. But going to your point, had he submitted an affidavit saying, here's the amount of time I spent preparing for that deposition, which is going to get lost. Now, again, I don't think it all gets lost. I understand that where you have something, you prepare for it, it gets canceled or rescheduled.
And just to sort of jump ahead, tell me where you ever conceded entitlement on this record?
Where I conceded entitlement?
I'm assuming the answer is I didn't.
I did not.
Okay.
But at the end of the day, where the rule says it has to be related to the failure to show up. It's like, and I'm gonna say this wrong, Ouroboros, right? The snake eating its tail. I file a motion for sanctions, and the sanctions I want are the attorney's fees associated with my motion for sanctions and the hearing. That's appropriate in certain circumstances. Under motive be smaller, appropriate. Under the court's own initiative, appropriate. If you violate a court order requiring your client to appear at deposition or an order compelling your client to make discovery, appropriate. There was no discovery order that was violated in this case. And this court in the Chimera case decided, I think it was in 2012, said you have to have that order before you can sanction under 1.380. The difference is if the fees are to get the motion to compel her, to get the order compelling, if the fees are I wasted a bunch of time preparing for or sitting at a deposition, you get those fees. But if the fees are I'm going to sanction you because you did something bad, you have to have an order. You have to have an order first that's been violated. That didn't happen. So because of the safe harbor, because there was no order violated, the entitlement should be vacated as well. And because there was no expert, and because this court has previously said, look, you get one chance and one chance only, and Mr. Carey went in eyes open with the understanding that he didn't have his expert. He could have asked for a continuance and then straddled the line, as you pointed out, and said, well, let's see if it goes my way. I don't think we reward that. I would ask that this court reverse remand, and vacate. Thank you.
Good morning, Your Honors. May it please the court. My name is Kevin Carey. I'm here on behalf of the appellee. If I may, I'd like to address the expert issue first, because it really, I think, was addressed in a rather misleading fashion in the appellant's brief. It wasn't as if I didn't know I needed to have an expert. Tom Scare, who's a board certified civil lawyer, was planning on being at the hearing. We filed the affidavit. When I got a call, this is all on the record, and it's also in the order. About an hour before the hearing, or an hour or two, Mr. Scare called me and said, I cannot be at the evidentiary hearing. So it wasn't, we talked about this one bite of the apple. I didn't ignore the rule. I had an expert. So
Mr. Carey, you mentioned there's some discussion on the record about a continuance. And then it just sort of sits there and the affidavit is stricken. There's not another request for a continuance to get Mr. Scarrett in light of his situation. And you decide to go forward with trial. And my guess is at that point in time, the court probably would have granted a continuance, but you decided to go forward with trial. And so once you take that leap and go forward, why should we remand if we decide that an expert is necessary, which I think it's pretty clear from our court that we have? Why should we remand to allow you to get your expert when you had that opportunity for a continuance?
I'll judge because the way it went, and there was no 3 different occasions I said I would seek
You
it.
did, but there's no grant from the trial judge, and you proceeded with the you proceeded with the trial. But
the judge says, I'm going to take a break. Okay, and the judge researched. The judge comes back, cites 2 cases.
And you got the decision you wanted, and you went with that. And that's the thing. Once you step in and you go to trial, and you got the decision you wanted, then you're left with the facts and the records, and that's what we have here.
Well, the judge made a finding that there was no need for an expert. To me, it's not no different if I had Mr. Scarrett in the back of the room, and the judge said to me, I don't need an expert. And by the way, the cases do say there's an exception. It says absent exceptional circumstances. And I think this is an exceptional circumstance. When I was there, I couldn't say, Judge, let's come back. I guess I could have, but he said, you don't, Mr. Carey, you don't need to have an expert. He ruled in my favor. I don't think I should be taking a risk there because Mr. Scarrett had a business problem. I offered for
the risk would be that there would be an appeal and
no, but if the judge has said you need an expert, he would have granted the continuance. There's no question about that. And so but I'm being penalized because the judge ruled in my favor, even incorrectly. So there are cases that talk about with exceptional circumstances that you should go back and allow this. I did not. I think this one by the apple issue applies when you when you ignore the rule. But I think this is an exceptional circumstance. My expert, an hour before the hearing, said he could not be there. If the court's saying I'm penalized, my client's penalized because I didn't force a continuance when the judge says to me, you don't need a continuance, Mr. Carey. I'm gonna rule in your favor. I think, again, it's like having found out the expert there, and he said, you don't need an expert. He ruled, you don't need an expert. So I don't know what I could have said. I don't think I'm taking the risk by proceeding. He comes back, and I do agree, by the way, the two cases the judge cited aren't particularly helpful. I was hoping to be more helpful than they were. But the point, I don't think that it's dispositive that I let the judge make a ruling. He controlled that courtroom, not me.
Were those the two cases where they read on the record? How did, when he came back?
But what he did, came back, but he just cited the cases, and he didn't go into much analysis. But he said,
He gave you the site.
correct, and I think they're even cited in the order, I think
Yeah, they
on
are.
the fee order. But I agree that they're not particularly helpful. They're not. But again, I don't know. If he comes back and he says to me, Mr. Carey, you don't need an expert. I don't know how I'm supposed to be held accountable to say, well, Judge, in case you're wrong, I want a continuance. I clearly at 3 different times in that transcript said, I will seek I'll pursue an amended notice of hearing for continuance. So I did. I wasn't ignoring the issue of continuance. He tells me, Mr. Carey, I'm giving you what you want. You don't need a continuance. I don't think I should be penalized by saying, well, Judge, no, don't rule that way.
So this goes really to your argument on how, assuming there's merit to the underlying challenge, this goes to your argument about what we should do on reversal and what you want is another hearing.
Well, I think, yes, although I think frankly what's going to happen, be careful which wish for, the hearing is going to be seeking more fees, because then they would be asking for appellate fees as well. It continues. They make an argument somewhere in the brief that and it was made earlier, that all I'm entitled to is the 1 hour for the no-show of deposition. That's not the case at all. We're in the court, had a fee hearing, took my testimony, and there was, by the way, no cross-examination. There's no expert on the other side.
Is there an end to your fee entitlement under this rule? Now, just to give you a contrast, and we had a case earlier today, if it was a 627428 type fee claim, until entitlement's conceded, your opponent's on the clock, right?
That's correct.
But here, the rule, the authority to impose the fees is directly tied to the discovery failure. And so at what point does it end? You've asked for your fees on this appeal, or tell us why.
Yeah.
Your fees on fees on fees on fees never ending.
It continues until they stop fighting entitlement. I mean, there's the standard differentiation between you get fees when you're fighting entitlement. You cannot get fees for fighting the amount of fees. If they come in today, if they come in on this appeal and said, we're not fighting entitlement, we're just fighting the amount, or the issue about the record.
So that's your bright line. Is
Correct.
if this appeal was limited to the amount of the award because they effectively conceded an entitlement, you wouldn't have a fee motion.
That's correct. Also, by the way, I think you do have the authority. I know there's case laws about remanding. If that's certainly rather than getting a reversal, I want to remand, but I think that's not good. This is go straight back to this judge. Again, we're talking about a $4,000 fee sanction, about 7 hours of my time. They're not going to get a better result with Tom Skerritt coming in as he was planning to come in that day.
And the trial judge awarded you exactly what Skerritt opined was reasonable fee, right?
That's correct, which was again 7 or 8 hours. There's not a lot of fees. There's no cross-examination challenging my fees. There's no expert challenging those fees. Again, so I'll leave that there. I think you do have the authority
Let me
to.
ask you a question.
Sure,
Jay.
Judge.
You obviously have been around a long time, handled a lot of cases. You know that when you go for attorney's fees, you need to have an expert to testify about reasonableness. That's why you got one.
Well, Judge, honestly,
Otherwise you could have gone in there and said, Judge, do whatever you think is reasonable, right? Here's what I think is reasonable, but you got Tom Skerritt because you knew you needed somebody. And he's
that's
qualified.
correct. Yeah, but I for a period of time had a black robe on, and I haven't had fee hearings where there was not an expert. So candidly, that is the law, and that's why I had them. So I was not ignoring.
Wait, can you
But
give
when
us a
the
case?
judge- So when the judge said, I'm going to rule in your favor, is there any obligation on your part to say, hey, hold on a minute, Judge, you got it. I'm not sure you're right about this.
I didn't honestly.
I don't have any cases going the direction that you're saying that you want to go.
Judge, I didn't honestly think that was the case. Honestly, when I researched this later, because again, they provided no cases at the hearing. These hearings are, they're providing 40 cases to you now. There are no hearings for the judge to benefit the judge to make this ruling. So I honestly, it wasn't a gotcha on my perspective, Judge. I honestly believe what I said at that hearing, which I did not think you always need a fee expert. And you think about it in this case, in this instance, when you have a $2,000 or $3,000 sanction,
I understand what you're saying, but
they can't hire a fee expert for $3,000. The point of the sanction and the 1.380 is to allow these trial judges to move these cases along. And that's exactly the opposite of what's happening. We're sitting here a year later before the appellate court when the trial judge does have great discretion in sanctioning. There's no question the court had discretion under 1.380. So I didn't mean to interrupt you, Judge.
that's okay.
So I don't know.
There's mention, and if you could help clarify for me, there's mention of a sanction motion that was filed before the day of the deposition.
No, what happened, and I'll leave the fee issue to you all. I think I've made my point, and certainly I'll respect your ruling on that. So let's go back to entitlement. That's number one. The court did make a finding that there was a knowing and intentional violation. So I don't know how much we need to get into the weeds of what occurred, but I'm happy to go into that with you. But the court made a factual finding.
Well, for my clarification, what motion was filed before the deposition date?
Yeah, there was a motion for sanction. Let me tell you what happened. And again, the issue was very simple. The issue is, was there a sanction? Did the court have discretion to sanction for a failure to be a deposition? And there does not need to be a court order, by the way. And I've cited, I don't mean to get off track, but I've cited the treatise of Berman, which makes clear in the trial
Court has discretion.
Absolutely, absolutely. There's not, but they have argued that there needs to be a court order, and that's not accurate. So I just want to make
I'm
clear.
just trying to get clarification of what the sanction motion was prior to.
Well, let me convey that. That went back. What happened was, back in August of last year, there was emails back and forth about setting the deposition. Okay? And so we set the deposition for October 30th of 2020. But these emails were, you'll see this is the record, we're in August. So he factually, again, this is rather factual, but my opposing counsel says I have a concern about that you were at a meeting regarding, and this was back tied to the divorce
And
case.
this all relates to the motion to strike the order.
Yeah,
And a disqualification.
right, but the fact, my argument to the court, which the court accepted was, and if you look at the Berman analysis, you can't just file a motion for protective order, 4 days before the deposition and say, I'm good.
Okay, so you're saying.
Didn't you file a 57-105 along somewhere in here?
No, the only motion for sanction we filed was, there may have been one filed on some other issue, but I don't think that's not part of this sanction.
So was the motion for sanctions here filed the day before the deposition?
No, I don't know, it was filed, I think it was filed the week of, but if I can go back a minute.
But let me get clarification now. Was it filed before the deposition?
Yes, because they told me that he was clear that they will not be attending this deposition. And
They typically don't you file a motion for sanctions after they appear? I mean, I realized the writing was on the wall, that they weren't going to appear, but.
Judge, I would need to check and see whether it was a day or two, maybe it could have been a day or two before, it could have been a day or two after. I just don't recall from the moment. But the point of it was, if you look at the Berman analysis, it talks about you need to immediately address the issue. The point I argued in my 12-page motion to the court was they did not meet that standard because they waited. My point, which the judge accepted against a factual point, was back in August, this issue of, Mr. Carey, you were at this meeting, were you not at this meeting? And then they talked about, they raised some issue about the emails were contradicted by an interrogatory answer. A lot of detail, which I think again.
That's what we're talking about appeal here, right? They've not appealed the motion, the denial of the disqualification or the protective order.
No, I think they're here just on the order getting the sanction. And I think also the order was denying the motion for reconsideration. But the point is that my argument to the judge, which the judge accepted as a factual matter. So I think, I think they're bound by this. They didn't really address this issue in the brief, was that they knew in August about the issue about me because the email said, Mr. Carey, we're concerned about that you were at this meeting. So the point I was making in October when I filed a motion for sanctions, in contrary to the Berman analysis, is you can't wait 2 months. The argument we made is that they could not, and the court accepted this and adopted the analysis of Berman. Mr. Berman's treatise was that you've got to move quickly. And they claimed they just knew about it in October. And our point which the court accepted, was they knew about this in August. So the fact you filed a motion for a protective order 4 days before a deposition, when you know you're not getting a hearing, is not enough. And what Bruce Berman talks about in his treatise, it's contrary to Treywick. Treywick says your motion for protective order is enough. Berman makes clear, and the discovery rules, the trial order section make this clear too. It's not enough. Just that does not toll and stay the issue, particularly when you've waited 2 months. It wasn't a couple of days; it was 2 months. That was a factual issue the court has resolved. So you can't come in and file a motion for protective order 2 days before a deposition or 3 days that same week and say, Judge, this is an emergency. He knew he wasn't going to get a hearing on that, but what Berman says, which I think is important, is you do that at your own risk. That's the important point. I briefed this in the motion.
And this goes to the judge's discretion on the
Absolutely.
entitlement issue.
But the point is, you can't just come in here and say, okay, I filed a motion for protective order, I'm good, which is basically what happened. So the court did find that there was an annoying and intentional violation of the discovery rules. That's a factual finding that the court made. And the court, I went back and read the transcript, the court went into great detail about this analysis. And the court did say it was not bad faith, but it was knowing and intentional and willful. And so
That is within the text of the rule.
Correct. So issue A is you don't need bad faith. Issue 2 is that you don't need a court order. So I think at this point, as the court knows, that you give broad deference and discretion to a trial judge's sanction. Of course, certainly the judge has the discretion in this case to sanction a party. And I want to talk about one other thing real quick. There seems to be some basis for Mr. Mitchell to suggest a higher standard because he agreed to take on all of the sanction. And that concerns me. What happened was we filed a motion. The motion we filed was against both the defendant, the appellant's client, and counsel. So the court's finding was clearly against both party and lawyer, which the motion was seeking. And at the end of the hearing, Mr. Mitchell said, "I'd like to frankly take a bullet for my client." And frankly, that probably may be the way it's been now characterized. Maybe I shouldn't have agreed to that. I didn't frankly really care. It was a $4,000 fee sanction. But it seems like in part of this briefing, they're suggesting a different standard because it's just the lawyer versus the party. And I just think that's would not be appropriate to somehow reward the appellant because of a stipulation to take a bullet on behalf of the client. And by the way, that's contrary to the Carlton Fields case, the Byrd case, which it's a second district case, which the court cited to, and it is also a lawyer. The firm was my former law firm, Carlton Fields, was sanctioned for for a discovery violation, and that was the opinion where the court rejected the bad faith requirement and just said there is no bad faith requirement. It talked about Mobley and the Supreme Court, which requires bad faith in a different setting, which is more of a 5.715 setting, but made clear that it said we disagree, there's no requirement for bad faith. And it sounds to me like the court is not accepts that point, so I won't argue too much more on that. So I think there clearly was an entitlement here. There seems to be an issue that you all will be addressing in terms of the fact that we didn't have an expert. I think my explanation to you shows that I did go for it. I think if the ruling is we're barred because I didn't force a continuance with this judge, I think that would be a harsh ruling on your part. And I think again the cases talk about allowing an exceptional circumstance, and I think having the expert witness coming in that morning and then learning just before the hearing that he could make it, and me asking 3 times that I wouldn't seek a continuance if the court feels like that's needed, I think that satisfies that standard. So I would, at this point, if you have any other questions, I'll stop talking. So we do ask the court to affirm the lower court and also grant our motion for appellate fees and remand the issue.
When you say exceptional circumstances, you're saying that you should be entitled to a new hearing because of exceptional circumstances. Is that?
Yeah, being that we had the expert.
Somebody lined up who fell through at the last minute.
Correct, and again, I don't know. I mean, when I'm at that hearing and the judge is saying you don't need an expert, it's a little hard for me to say, Judge, yes, I'm demanding a continuance when he's telling me you don't need a continuance, Mr. Carey. I don't quite see how that's gonna happen. I understand the point, and I guess the point being, if that was my obligation to force a continuance, but I didn't.
Well, I think the point is that if the law is clear that you need an expert, and the court says, no, you don't, and then you proceed knowing that this may be an issue going forward, that you should have had an expert, and the judge is not ruling with what I believe to be well settled as far as an expert, then I think you go down that path and you take the risk that it might get reversed.
Well, but
on that basis.
the court cited 2 cases that he came back with and said these cases were the proposition. I can say this: it was not a situation where I knew for a fact the law always mandated that. I would not have, and I did at the hearing suggest that, and I honestly, in good faith, did not think that was required in all instances. But when he came back and cited 2 cases without really talking about it, he said these cases.
You should have read them first.
I'm sorry.
You should have read them first
Well,
before citing them. They don't help his position.
well, my point is he cited. You're saying he should have read them first.
The judge should have.
Well,
And
he
then maybe
claimed.
made a different decision
He
about
claimed.
using them.
Well, but if that had happened, he'd come back and said, Mr. Carey, you need an expert. I would have said, fine, well, we'll be back in 3 weeks. I mean, if he had ruled the other way, there's no question in my mind that he would have granted my continuance, which I asked for on 3 different occasions. I don't think I should be penalized by saying I ran the risk by asking the judge to make a ruling. The judge, that was in the judge's hands.
No, I think the point is it appears you knew you needed an expert because you had the affidavit. And then you also requested a continuance based on that. And when the judge came with the out, albeit on 4 cases that you didn't, you went forward.
Well, the judge ruled. I wasn't going forward. The judge ruled. I wasn't going forward.
And it's very difficult to tell a judge that they might be wrong, especially when you don't even know what the cases read. So, and I realize this was COVID and on the phone. It's a very difficult situation. Maybe it would have been in hindsight better to look at the cases and see what he was relying on if it appeared to be inconsistent with what you knew the law was.
Well, but that's asking a lot of the middle of the hearing. He says these two cases support my argument.
It's a heavy lift to say, Judge, you're wrong on the law. I want my continuance. Let's go
Correct.
forward. But there are lots of situations when you come and you have a decision to make about, say, going forward to trial when one of your witnesses can't make it. And you say, well, I'm going to take my chances. I mean, it's not unprecedented that these situations come up where you have to make a judgment call.
Well, you do, but I think
And I'm
again,
not sure how this is going to settle out in the end. But
well, there's a lot of criticism, by the way, in the literature about that ruling, that you always have to have a fee expert, because it really is it's a difficult task when you've got
there may be
$2,000
criticism, but what I was hoping to see, and I'm still open to it, is if you've got any kind of authority, a case that you can say, here's a situation where you don't need the expert on fees. I didn't see it in the briefing. I'm not aware of it. I looked at it on my own. I'm just not aware of any authority for that.
Well, what I'm saying is then we would request, you do have the authority to grant a remand back under these circumstances. Again, I think the clear distinction I think to make for you is if we had not brought a fee expert, I think you would have the ability to say, look, Mr. Carey, you can't get a second bite at the apple. But that's not what happened. When you have a witness who an hour before the hearing says he can't make it, to me, that's an exceptional circumstance. So
But then you
if
don't
you,
go, but you don't go forward with a hearing. I mean, typically some of those cases in the finger, they look at whether or not you should proceed, and the court denies a request for a continuance. We don't have that situation here because you agreed to go forward.
well, but it wasn't. But okay, I don't mean to go into circles, but he says, Mr. Carey, you don't need a continuance because I'm ruling in your favor. I'm not going to say to that judge, you're wrong.
No, all due respect, Judge, I think I'll take the continuance. I mean, that's,
But the judge doesn't rule for me, Your Honor. I mean,
that's the risk though. That's the risk.
Well, I honestly, at that hearing, I do believe, I've had hearings where there's not been a fee expert. Maybe that's by stipulation. And again, these courts do talk about,
And
with
typically
exception.
people resolve with affidavits and, and.
Well, we filed an affidavit. The record does have affidavit. It's in the record. It was
But there was no
excluded due to hearsay.
stipulation. Yeah, there was no stipulation that it was gonna go forward with affidavits, obviously, because the court struck it.
Well, right, it was not admitted based on hearsay. So yes, we would request that if the perception is, we need to have a fee expert, I think that these circumstances would allow the court discretion. This wasn't, otherwise I think it's would become a gotcha situation. Because it is awfully hard for me in that situation to say, Judge, no, I don't want what you're giving me because I'm gonna get reversed by the second DCA.
Sure,
So,
understood.
and I can't even frankly think I'd be equal with the second DCA on a $4,000 fee sanction either. So, you know, I think, and I appreciate all your questions and thank you very much.
Thank you, Mr. Chairman. Response?
Well, Your Honor, it's important. It's only $4,000, okay, but I was sanctioned. I was sanctioned when I followed.
We're not minimizing it.
I was
I
sanctioned when I
understand that
followed what
comes out of your
Traywood
pocket.
said to do. I was sanctioned when I did what I, in 20 years of practice, have done countless times before without an incident. I filed a motion for protective order in good faith. I tried to set it for a hearing. It wasn't set. And I understand, we talk about discretion, and I get it. But discretion ends when the rule says something different. The rule in this case clearly says that when you file a motion for protective order, you're excused. And I would ask that this court reverse on entitlement as well. Judge Smith, the motion for sanctions was filed after the deposition period. It was the same day, but it was later in the morning. That wasn't so hard to correct the record and tell you that you may have been mistaken about when the motion for sanctions
Well, I
was filed.
think there was a motion for sanctions. It was a 57-105.
That was
I went back and looked at the record.
But
I just wanted to make sure it wasn't the one we were dealing with.
it is a tough ask to say that sometimes we have to disagree with the Black Robe and say, I think this might be wrong, but we do it. We do it when we know that the law is what it is. And again, the law just couldn't be clear about needing an expert at a fee hearing. It's called getting out of Dodge, right? When you get a hearing in your favor and you feel good about it, but there's something in the back of your head saying maybe it shouldn't have gone that way, you just grab up when you're in court, you grab up your binder and you get out of Dodge, right? You get that here, you get that rule. Well, you run a risk.
Well, you ran a risk on the entitlement issue by filing a motion for protective order within a handful of
It
days.
didn't appear to be the case here. Again, and I guess Mr. Traywood.
I mean, everybody here has been a lawyer and two of these people have been trial judges. We know how it works with depositions
Right.
and what it means to file a motion for protective order at 11th hour on a deposition, and you were at your peril under that rule.
Again, respectfully, I would respectfully disagree with this court and say that under 1.3 of the, you're not. And again, if the motion for protective order is in bad faith, mostly be small.
Or an intentional act, the failure to appear.
Right, but again, I just want to read it one last time. The failure to act described in this subdivision may not be excused on the ground that discovery sought its objectionable. Let's stop there. We failed to act. We failed to go to the deposition. It was intentional. It was willful. Okay. We objected though. We objected to Mr. Carey taking the deposition because we believed he was a material witness. Unless the party failing to act has applied for a protective order as provided in 1.280C. We did that. Regardless of how you rule on the entitlement issue, I would urge you to write on that issue because I think it's important because it's always been my understanding, apparently with Mr. Traver's understanding, that as long as you file a motion for protection, again, as long as it's not in bad faith, maybe at the 11th hour, I would respectfully disagree. I don't think 8 days before deposition is at the 11th hour, but you're in the clear. The other point is Mr. Carey stood before you and said the point of these sanctions is to move cases along. Then what was the point of these sanctions? The sanctions didn't move the case along. The sanctions didn't get Mr. Carey discovery that he couldn't get, that I was refusing to give to him, because by the time those sanctions were ordered, the discovery had already been done. The deposition had already been taken.
Go ahead and wrap up your argument, Mr. Mitchell. You're out of time.
I'll wrap up my argument. Thank you for your time today, Your Honor.
Thank you.
Thank you, Judge. Appreciate your time.
Brings us to the last case of the day, SHM Cape Harbor